Hello and welcome to NavTalk. NavTalk is proudly brought to you by the NavWealth Financial Group, helping you reach your destination in life on purpose. My name is Simon Prowse and I'll be your regular host for this series of podcasts. And I look forward to bringing you interviews and content on a broad range of topics. Topics that will be educational, inspirational, informative and at times fun. Well, hello everyone, and welcome to today's NAV Talk entitled, It's Not Just a Will, a Smart Will. My guest today is Michael Fitzpatrick. Michael is the principal and founder of Fitzpatrick Estate Lawyers and a firm specialising in estates and family succession planning. Welcome, Michael.
G'day, how are you going?
Oh, great, mate. And thank you very much for talking with us today.
It's a pleasure.
And a topic that I think will be absolutely fascinating for many people out there. Michael, tell me a little bit about how you got into estate planning and family succession, your journey.
Well, I've been a lawyer for 46 odd years, and in my I think it was the first week of my journey through a legal career as a 17-year-old article clerk for a firm in Parramatta. I was asked to prepare a will for someone. I'd only just left high school, and I'm joining a firm, and here I am drafting wills. That is a good demonstration, and it still persists until today, at who does the wills in most legal practices. Often it's the person at the very bottom end of the food chain, because they're not given a lot of thought. They're just throwaway things, standard forms. So that's where I started, but I then embarked on a career which took me to Broken Hill in the early stages of my career. And one of the first cases, I was a compensation litigation lawyer, and one of my first cases there was a situation where a grazier and his wife had two sons and one property. And so, as was the custom, the property went to the eldest son, and that was pretty well the only asset. The property wasn't big enough to divide or subdivide, so it meant that one son ended up with no inheritance. He wasn't very happy with that outcome, and so I became involved in, I suppose, trying to settle that almost insoluble dilemma that happens there. But something as simple as that is. You see that on a day-to-day basis in estate planning. I then, over the years as a compensation lawyer, got to the point where I was, in fact, I held a record for the largest amount of compensation in a case in Australia. And I became involved in helping that individual who was an 18-year-old who suffered brain damage in a car accident on his last day of school. I became involved in the management of his affairs because he won a whole lot of money. But I went looking for a competent financial advisor to be able to give information and advice to his. So I sat down with a few people, and including public trustees and what have you, and went out to tender. What I found was that there's not a lot of assistance out there. So what I thought from that, I better maybe learn a bit about this myself. So I've signed up for a financial planning course, which I did, and then went looking for a competent financial planning firm that I could work with, and that's how it started. Ultimately, I got qualified fairly extensively in financial planning, and indeed worked for a financial planning firm for a while. So I've had a career that took me from law into financial planning, that took me into tax planning, that then took me into estate planning. And so for the last 25 years, I've specialised in estate planning, and I've done that right round Australia. I was a partner at PricewaterhouseCoopers. I headed up the estate planning team there. And so I was exposed to all of the firm's clients, some of the iconic wealth in Australia, all different shapes and sizes. And I did the estate planning for virtually every one of the 500 or 600 odd partners in PwC. Incidentally, it's interesting to reflect on. I don't mean this is any criticism of PwC, but it's pretty typical. None of them, I could count on the fingers of one hand the number of partners who had a good estate plan in place. So these are very intelligent people with credentials all over the place, but even they most of them hadn't had an opportunity to sit down with someone who would help them make important estate planning decisions. So And that leads me in and ultimately retired from there, and I've gone back into my own practice now where I'm a lot smaller, but still doing estate planning day in, day out for all different people and for all different shapes and sizes of people.
So I liken that to a bit of a plumber with the leaking tap story. These guys are so busy, or ladies and gentlemen are so busy, that they don't even look at their own backyard.
Well, that's right. And I mean, half the population in New South Wales dies without a will. If it was easy to do, that wouldn't be the case. You'd have more people dying with proper arrangements in place. So, it's
not exclusive to these PwC partners. There's plenty of people out there.
No. That's right. A lot of those people had wills and stuff, but they weren't very good wills. So this comes back to this concept of a smarter will. And there's a lot of dumb wills out there. Okay. So if you're going to have a will, let's have a smart will rather than a dumb will. We'll
take the journey down into the will and the formation of that. But from what I understand, it's bigger than just the will. It's about a planning for your estate and the protection of assets. Is that a fair assumption?
Well, it is. Estate planning is really three things. It's first of all making sensible arrangements while you are alive, so that if you were unable to attend to elements of your legal and financial affairs, that you've appointed someone that you know and trust to make those decisions for you. If you're out of action because of some physical impairment or start to go a bit gaga, you need a trusted family member or members there to sort of deal with all of that. The other option is you let the public trustee or the guardianship tribunal decide who would look after your money. Now, any of you have seen in recent days some of the articles on 730 report and what have you. Having government involved in any element of the management of your affairs is the last thing that any family would ever want to see.
Yeah, well, they'll have good intentions. They just don't know your family circumstances.
Well, they don't, and they're costly, and they provide very poor service. I have not met anyone who bragged about how good it was for a government official to be involved in administration of affairs. In some people, there's no choice. It has to be said, in which case, where they don't have any family, then there's a role for a public trustee. But mostly families with proper assistance by competent advisors can do a really good job at managing their other members of their family's affairs, especially children. Honest children can do a really good job looking after their parents' affairs, and that's the way it should be set up. So the first job is to appoint via power of attorney people in your family that you know and trust. Now, there's a lot of issues just there. Do you appoint one? Do you appoint two? Do you appoint them jointly? Do you appoint them separately? What happens if one of them's overseas? How do you deal with differences of opinion, what have you? So you need to craft something which is going to work within the framework of each and every family, and there's no two families the same. Secondly, you need to appoint someone to make medical decisions for you during periods of time and you can't speak for yourself. If you're unconscious or going a bit wobbly and you can't have a conversation with the doctors and hospitals, you're at the mercy of the system. And, the system tries its best, but without someone who's been appointed to deal with doctors and hospitals, then you're not going to get an effective result. So an appointment of enduring guardian, it's called in New South Wales, and it's separate to the power of attorney, and it only deals with medical and lifestyle affairs. Where do you live and what doctors and hospitals you go to and whether or not it's termination of life support, those sorts of type issues are all important issues. Now, once again, there's no two families the same here, and who you appoint and how you appoint and what conditions you'll apply need to be sussed out during the process of putting together an estate plan. There's no one-size-fits-all to any of this. And then finally, estate planning is about what happens to your wealth when you're finished using it. Generally, we're pretty fussy about that. We've made a lot of sacrifices in putting our wealth together, and generally we want to make sure that any unused wealth gets safely deposited in the hands of people who are near and dear to us, and not anybody else. Now, that just can't happen through wishful thinking, and it can't happen necessarily very well with a $2 will, written by someone who's never written a will before in their entire lives. So this part of the exercise, this reliable, effective transfer of wealth from one generation to another is vital. It is crucial, and it's probably one of the most important decisions that a person will make in relation to their family. Because if you get it wrong, the costs of litigation and what have you is enormous. Hundreds and hundreds of thousands of dollars typically wasted on legal fees because you haven't done a good will or you haven't done a smart will. And so many people make mistakes, are poorly advised and think they can say anything they like. No, there's a whole lot of formalities that need to be observed. And generally they'll get a better result if they get some decent advice from people who have some sort of expertise in this area.
So that sums up the estate plan. And can I just ask a few questions around that, which has been really interesting? You mentioned the power of attorney under arrangements whilst living, and then the appointment of a medical decision maker or enduring guardian. How's the interaction generally happen between those two parties? Are they one and the same?
Often they're the same people. They're generally children. But the medical guardian needs to be someone who's close by, a Johnny on the spot. There's no point in having a medical guardian who lives in London if you're living here in Australia. So you really, because that person might have to be there at 2 o'clock in the morning when you're having a seizure and decisions made about which hospital to go to and whether or not to do certain things. So this is where you need to have a long, hard sit down and look at just what talent is available within the family. Now, sometimes noses can be easily put out of joint if you don't get this right, because many of these decisions are political decisions within the family. So if you appoint your youngest daughter because she's a nurse, that might offend your eldest son, who might think that because he's the eldest, that should be him doing these things. So this is why estate planning is not something that's done in secret. You actually have to sit down as a family and sort these things out and come to arrangements which are going to work. So it's not a form, it's a workable strategy, ultimately documented by the use of forms which will achieve the desired result, and that is the protection of your wealth while you're alive from people who might want to take advantage of your old age, someone who's going to do all the hassling with doctors and hospitals when you're not able to do that, and then finally someone in relation to your will who's going to be a competent executor and who will, once again, a trustworthy person who's going to get good advice along the way to make sure that your final wishes are carried out.
So you could have a different person being the power of attorney whilst you're living versus what you mentioned, the executor or the trustee of your estate in death. Is that fair?
Yes. And you might want to change that from time to time. I mean, many families have children overseas, and that makes it a bit difficult for them to, certainly it's hard for them to be an executor. Certainly it's hard for them to be a competent, a helpful medical guardian as well if they're not there to make decisions with doctors and hospitals and what have you. But so this is why all these options need to be looked at and decided upon and then communicated to the individuals concerned, because with the power of attorney and with the appointment of enduring guardian, the nominees, the people that you're nominating, have to actually sign and accept the appointment formally on the documentation. So
before death?
Well, it's before they can use it.
Right.
So wouldn't it be a good idea if, as you having signed your power of attorney, that we then get your children in and have a bit of a discussion with them about what it's going to mean if ever they have to do this, and what does the law say about what they can and can't do. Now, there's a very strict integrity regime which applies to all of this, but if you've never been an attorney for someone else before, then your ignorance and your naivety can let everybody down. So this is why a little piece of education is necessary here, because you'll always get a better result if the documentation is well drafted and the people who you're appointing are all it's been properly explained to them. They know what to do.
So the old-fashioned way of cloak and dagger around a will and all in secrecy is a total myth. It's much more open, transparent and discussed.
If the people that you are involving do not know about it, then you have failed to do it properly. So the only time, people in the past used to play their cards a bit close to their chest, because invariably they were favouring one child and not another, or doing something else that was a bit sort of maybe funny. And so they didn't have the courage to tell everybody because they knew it was going to cause an argument. But that's okay, the argument still happens. So we have, a $200 will turn into a $500,000 will because of the arguments that it creates. What a great result from an estate plan. So you haven't got a cheap will at all, you've got a very expensive will. And I see that all the time. Just to give you an example, a recent case. This was a case where both husband and wife had been previously married. they've got children of both of previous relationships. Husband says to the wife, the last thing I want to see, dear, is any part of my money get anywhere near your kids. I don't like any of them. And so what he did, he left his entire estate, not to his wife of 20 odd years, but to the children of his first marriage.
Right. And how did that eventuate?
Well, how do you think? How do you think?
That was shocking.
Yeah, I know. So what do you think the court did?
They gave it apart to the kids on both sides.
Well, they undid all of that because his first duty is to his wife.
Right.
And so, and then anyone, I mean, the local barista will tell you that that's not going to work. But that's what people do. So, and what happens, unfortunately, is that there's an enormous cost then paid for stupidity in doing this. Now, what that person should have been said, I don't care what you do, you've got to look after your missus. She's your second missus, but that doesn't make her a second-class citizen. Now, let's look at other ways where we can finesse these arrangements here so that you can leave an inheritance to your kids. There's always ways to do that with proper advice. So with a smarter will, you can achieve things where people aren't being left out of their inheritance.
Generally, with the family discussion, if you like, I dare say that brings out a lot of emotion pre-death, and you sort of get it all out on the table, and you can really work through that. Do you find that happens a lot?
Generally speaking, it's a relief.
Yeah, right.
More than anything else. Children, particularly adult children, are just happy that their parents have got something in place. They're reassured that the parents' affairs are in good order and there's not going to be a shit fight. That's a technical term for when someone goes. The other thing is the children need to know who's going to be the executor and who's going to make funeral arrangements and where the documents are and who the advisors are and who's the accountant, because they've got to finalise tax returns and what their wishes with regard to funerals and what have you. I got an interesting case at the moment where the eldest daughter of the first marriage is the executor. The guy has just died. He's been married to his second wife longer than he was married to his first wife. But the eldest, the daughter who's the executor, wants to bury him next to his first wife. Interesting.
Have we got an answer on that one yet?
Well, the law says that the remains of a deceased person belong to the executor. So the executor can do whatever they please.
Right. So he probably will end up buried next to his first wife.
That's where he went, and not a thing that can be done about that. So there was an interesting Aboriginal case just recently in the Northern Territory where a famous Aboriginal he had been married twice, and generally First Nation people want to be buried on country. But this person had sort of two countries, I suppose, his second wife's country where he sort of became associated. But that was the most recent decision. And once again, the Supreme Court in Northern Territory said, it's the executor's choice.
Okay. Well, that's fair. We've got to have someone make that final decision. You briefly touched on it previously or earlier in your talk. I just want to circle back around a bit. You mentioned 50% of people die without a will, which is scary.
Oh, yeah.
What happens in that process? You die without a will, you're in the government hands. Is that fair?
Well, no, it's not. It's just you've got your family's left to deal with a whole lot of crap. It's costly. It's chaotic. It's confrontational. It's expensive. It takes a long time. No one has ever been able to advance an argument which says it's a good idea to die without a will. Now, everybody will accept it's a prudent thing to have a will. Our talk really is today is, wills, wills ain't wills, oils ain't oils. So a will where you just scratch down a few little things might get by, but it's not still going to produce the effective result. Now, an effective result is the cost and tax efficient transfer of wealth without disputation.
I think the dispute part is probably the critical one in that.
It's very easy to rub people up the wrong way if you don't do Now, I've seen people, grown up 50 and 60-year-olds, fight over rusty old lawnmowers and wheelbarrows with holes in them. When you get this sort of like feeding time in the shark tank, mum dies and suddenly everyone's there at the house helping themselves to bits and pieces. It's very unseemly to see it, but where you don't set up the right structures, That's what often happens. So it's every man or woman for himself. Now, this is why I say proper estate planning is a family job. It's not just you to do something and think, oh, well, let them fight about it. What an absolute disaster that is. Really. I mean, how anyone with any good sense could adopt that attitude. If they had any affection at all for their family, they'd want to make sure that that the family wasn't subject to all that unnecessary tension and expense and delay. But dying without a will is never a good thing, because it's just the first thing. Who organises your funeral?
Yeah.
Who does that?
It's messy for the moment it starts to the moment it
So, the executor is the person who does that. And if you haven't got a will and appointed an executor, well, then the very first thing. So...
Does that normally fall back to a spouse, or would that be wider reaching?
Well, generally it's some relative will have to make some sort of application, what's called letters of administration. Yeah. But you've then got to go and prove. I've got a case at the moment where this young man, well, he's in his 30s now, his parents were divorced 30-odd years ago. They never got round to having a divorce, though. He's the only son. Dad has told him over the years, oh, yeah, I've done a will. Yep, it's all going to you.
Well, he didn't do one, did he?
He didn't do one.
Right.
So he's still married to this woman, technically, that he hasn't anything to do with. And she's in a nursing home with dementia.
Oh, no. Okay.
So this is the only person who can make an application to the court is this young man. But one of the first things he has to do is to prove to the satisfaction of the court that his old man didn't have any other relationships, didn't have any other children. So we've got to go to this trouble and expense of checking that out and then trying to find a will. And that means checking with all his lawyers and with all his banks and all the other things. But what it means is this money is going to go to someone quite against his wishes, all for the simple matter of a basic even a basic will there would have been better than what he's just done to his son. What a great way to reward the affections of an only son, to leave him with that mess.
Well, I dare say the lawyers, a lot of the estate went to lawyers in that process.
No, well, I'm the lawyer in that case, but it's still a lot of trouble and it's double the expense than what it would otherwise be. But I'm talking to the guy and he's crestfallen, he's really pissed off and unhappy because he's been misled all these years for no good reason. He's but all this trouble and expense. He's got a busy life to lead. He's getting an inheritance, but he's not getting it because it's all going to the wife, the technical wife, who's got dementia in a nursing home. Incidentally, now that she's got this additional assets, over $1 million, it's she's now losing her social security.
Oh, golly gosh. And has she probably got family from a next relationship?
No, neither of them had any other relationships after they divorced. But so she's lost her social security, which means that her accommodation fees are going through suddenly have to be reassessed and going through the roof. So there's a whole lot of other adverse issues that cropped up because of this man's dereliction, really.
The mess it leaves behind in your death.
Yeah.
Tell me, when we die, I think that the formal word is a creation of a trust, or a death creates a trust because we're not in existence, so in nature it's a trust. Tell me a little bit about that process and what it means. So we pass away and then what happens?
Well, if you've got a will, then all of your assets fall into the hands of your executor, whose job is to distribute those assets in accordance with the will. So in a sense, your executor is holding all of your wealth on trust. And the terms of the trust are, here, hold all this and go and do what I've said in the will about how you're distributing it. So in a sense, every will is a trust. But there are trusts and there's trusts. What many people in this day and age are advised to do by their advisors is to incorporate in their will what are called testamentary trusts. There are two ways to create a trust. You can create a trust during your lifetime, or you can create a trust in your will. So a trust created in your will is called a testamentary trust. The advantage of a testamentary trust in a will is it ticks a lot of boxes for the modern family. The biggest concern that most parents have as they consider leaving stuff to their kids is what can I do to protect my child from losing their inheritance in a family law breakdown? If you leave assets to someone without any sort of protection, well, then it could be lost to someone that you don't like.
Because they're their asset rather than a trust
Correct.
asset.
So what trusts are widely used in wills is to provide some element, some effort to put a protective wrapping around an inheritance to make it, to try and quarantine it from creditors and predators and various other things. I mean, you've got to be, and that requires a great deal of skill because you need to know what you're doing in terms of the way that you create those trusts. The second advantage of these testamentary trusts, if properly drafted by someone who knows what they're doing, is it can create an enormous tax-saving concessions, which can add enormous value to the value of the inheritance. Now, we don't have death duties in Australia. They were abolished in the late 70s, thanks to Joe Bjelke-Petersen, incidentally. But they were replaced almost immediately by an array of other quite complex taxes that work like backdoor death duty. Capital gains tax, superannuation death benefits tax, sometimes GST, and other bits and pieces of taxes can all intrude into an estate. Now, capital gains tax is the big one here because what often happens when mum and dad both die and they've got one or two properties and a bit of super and various other things, a lot of these assets need to be cashed in to facilitate a distribution of the assets. That means selling it. So those Commonwealth Bank shares that mum and dad bought for $5.70 20-odd years ago when they first listed them, and they're now worth over $100. Well, then there's an enormous capital gain there. So as those shares are sold, then a significant part of that will be lost to tax. But it doesn't have to be that way. With a bit of planning and structuring in the will, you can set up all kinds of strategic options which can make an enormous difference. Now, it may well be that one of the kids will be happily say, look, I'll keep those Commonwealth Bank shares. I'll just add it to my portfolio, in which case those assets can go via the will, if the will allows this, to that child as part of their share, in which case no triggering of a capital gains tax event occurs.
It's just a transfer rather than a sale and a purchase.
Correct.
Yeah.
So but you need a provision in the will which gives the executor power to what's called appropriate assets. Now, I'm now talking about a smart will, not a dumb will, which is what you get if you're spending anything less than $1,000 or $1,500 for these things. So you need to be speaking to someone who knows how to put these sorts of wills together. But a smart will is a will which saves tax. A smart will is one which will help protect the inheritance from all the things that can go wrong with a beneficiary's life, from divorce to bankruptcy and what have you, and a smart will which promotes keeping this wealth within down the generation, so it can be used and reused and passed down. So those are the things that most people want when you sit down and have a decent talk to them about what their intentions are. And you know what? When you include the family, they all think that's a good idea too. I've never met a beneficiary yet who complains about saving tax. I've never met a beneficiary yet who is happy that it would appear that, and there's some trouble gone to make sure that he gets his fair share. Yeah. They never complain about it. They're very happy about it. And the other things, I never met a beneficiary yet who complained about not losing his inheritance because he had one drink too many and had an accident and caused a whole lot of damage and is on the verge of bankruptcy.
Okay. There's some interesting points that come out of that, or questions from my mind. You mentioned that you could cut up assets, if you like, of mum and dad and leave it to the beneficiaries, but they might form a particular asset, for example, your Commonwealth Bank share. How do you sort of let's say I had 3 children, I wanted to give them equal shares, and I just said equal share of my estate. How does your executor split that in a way that's meaningful and we can get these rollover benefits? Is there a way to do that?
Yeah, there is. So this is where the mistake that a lot of people make is being overly prescriptive. So you might see in a will, I leave my portfolio of Commonwealth Bank shares to my 3 children equally. That's a disaster. That's a disaster because they won't want to hold it equally. Now, the other thing is, when you've got more than one person holding a share, who votes at the annual general meeting?
Yes.
Well, I can tell you, the person whose name appears first on the share register.
Yeah.
That's what the ASIC laws say. So then, of course, two of them will say to the third, look, we're not interested in holding on to these shares. How about you have our bit and we'll have something else? That arrangement triggers a disposal of that of 2/3.
Right.
Now, the smarter will says this: I leave my estate to my 3 children equally, but I give my executor the power to appropriate particular assets in ways agreeable with all the parties towards satisfying their share. So in that event, one child might say, look, yeah, I'll have the BHP shares or the Commonwealth Bank shares. Yep, we'll work out what they're worth and they can be just deducted from my share of the estate. So that once we work out what that value is, so that can happen, zero tax. Incidentally, if it's a piece of real estate, zero stamp duty. So a 3-line appropriation clause in a will creates a tax-free platform which allows the various beneficiaries to come together and horse trade, do deals, which is what happens anyway.
Okay.
Because each beneficiary will want to get their share and go off and do their own separate thing.
Which makes a lot of sense, right? Because they're going to have a different lifestyle and a different approach to income and assets than their brother or sister.
Exactly. The Productivity Commission just did a recent, released a paper recently on inheritances. They found that the average age of a person getting inheritance in Australia is between 50 and 60. So you're getting your inheritance and you're between 50 and 60. One of the things that you might want to do with your inheritance, especially if you're getting good advice, is to top up your super.
Yeah, that makes sense.
It does. Makes perfect sense. So you don't want to be having a half owner so you want to get your little bit and be able to put it into your super. Who knows what your brother and sister might want to do? One of them might want to take a holiday. One of them might want to pay off their mortgage. So every beneficiary will have their own little list of objectives that they want to do. So leaving them something so they all own it together is not something that they'll want. Creates the worst possible tax scenario, and once again only leads to the potential for disputation.
Oh, absolutely. The conflict raises its head again. Now, you've mentioned the testamentary trust is created on death, but let's say we've got 3 adult children or 3 children, adult or not. When we're contemplating the will or the establishment of the powers of what we may do, are we essentially creating testamentary trust for each of those beneficiaries rather than one?
Yeah, that's the preferred way to go, because each beneficiary will want to run their own race. One beneficiary might just want to go and spend it or pay off their mortgage or whatever and doesn't need a trust. That's fine. He should be able to do that. So the idea is that you create a separate testamentary trust, one for each of your children on the basis that they can go and each run their own race. That's the way they want it. That's whether you do it for them or not. So we may as well give it to them in a way which is attractive to them, and in the hope that using the trust will help protect their inheritance. It will provide tax-saving opportunities, and it will afford each child the ability to be able to share their inheritance with their own children and grandchildren.
So that testamentary trust, could actually then benefit that beneficiary's children and the people they want to benefit.
That's exactly what it's designed to do.
And it can stay intact, that testamentary, in perpetuity?
Not in perpetuity. 80 years from the date of death is the law at the moment. But what it does mean is that not only your children can benefit, but so can your grandchildren. And indeed, maybe even your great-grandchildren. Hey, what a great thing to contemplate is the ability of the inheritance that you're leaving your child to be applied by that child towards the university fees of their grandchild with tax-free dollars.
And being a testamentary trust, the tax-free benefits to minors and like flow down with that trust too.
Correct. So each minor, each beneficiary who's under 18 who might benefit, whether it be a child or a grandchild or a great-grandchild, is treated as an adult for tax purposes because of a specific provision in the Tax Act, Section 102 AG2C of the Income Tax Assessment Act 1936, provides that very favourable tax concession for infants in the family. So this is where a well-drafted testamentary trust is the best investment money can buy, really, if you're looking to set up a parcel of wealth for a couple of generations of your family. And
tell me, given that the testamentary nature of the trust and the fact that you could have next generations, if you like, benefiting it, how's the process with getting clearance from the ATO around this? Because this is pretty big when it comes to tax saving.
Well, it is. All that the tax office wants to see is that the income being generated is from an asset that was left in a will.
Okay.
So what triggers these very special concessions is someone dying and then a trust being created in the will where infants might be beneficiaries. So if you've got a connection between the deceased asset and the income being generated from the investment of that or whatever going to an infant, that's the connection that you need to show. So, and that's generally not a difficult thing to do because you've got a will and you've got probate and you've set, and so a little bit of technical assistance from a competent advisor, accountant is generally necessary. Incidentally, one of the most significant duties under the law for an executor is to finalise the debts and pay the taxes of the deceased. Indeed, if they don't do that, the executor becomes personally liable for all of that. So in most estates, there's a need to do final tax returns for the deceased, and often, depending on how long it takes to tidy up the estate, there's a need to do a tax return for the estate as well. So I say to the children at the family meetings that I generally encourage after all the wills have been signed as we explain what the parents have done, is to say, look, there's only three things to remember, kids, when it comes time to get your inheritance, and that is get good tax advice, get good tax advice, get good tax advice. And they remember that. But when they hear that if parents' affairs are in good order, that there's going to be an equal division of the estate, that they're going to have the ability to be able to finesse how things are split up. They'll each get their own separate little trust that they can do. They run their own race. Oh, they're happy. They're as happy as Larry. So they're generally very appreciative and say so.
In the trust or the testamentary trust, and let's say there's a pot of money that's put aside or a group of assets, and you mentioned that group of assets, or you like, form the testamentary trust and then give it the exemplary nature or exemption. Is that trust then allowed to generate its own income?
Yes.
And it can then grow in its own regard?
Absolutely. Yeah, exactly. Well, it will grow. I mean, you might decide to sell those the Commonwealth Bank shares and go and buy some, put together a properly constructed, well-diversified portfolio, so long as it all is sourced from the estate of a person who has died. Okay. The growth of it and the change of the investments, what have you, those concessions will follow all that through. But if you went and brought some other money in from outside the estate into the trust, which trust you can do, then that component doesn't drive those special concessions for infants.
So we could be splitting the trust assets in terms of how that's managed.
Correct. So you just need to, your accountant just needs to keep. Now, a lot of people say, oh, these trusts must cost a fortune to run. No, they're very simple to run. And indeed, very invariably, the cost of running them is a small price compared to the amount of tax saved.
The benefits of it. And in terms of the beneficiaries of a trust, and I'm being a bit technical because, as you know, I'm an accountant, the beneficiary is supposed to be distributed the profits of a trust in a year. Let's say the beneficiaries distribute that money and they're a minor and they don't have use of that money and they leave that money in there as a present entitlement, which they could always draw. The trust then assets are growing because it hasn't had to divest itself. Is that allowed under the process?
Absolutely. As long as the allocation of that taxable income is being reported to the tax office. Now, if that allocation of income is below the tax-free threshold of the infant concern, which is close enough to $25,000 with the low-income rebate and what have you, then there's no tax paid. But then if that is kept within the trust to accumulate, yes, that will always belong to that minor. Can't be used to anybody else. So it's a debt due and payable, ultimately.
When that minor is entitled to some money.
Correct. And that might be in a few years' time he's got to pay his university fees or help with a deposit on a house. You don't want to have to give it all to him now when he doesn't need it. So, yeah, this ability to be able to accumulate is an important part. So, once again, a smarter will allows all of these things. A dumb will doesn't.
Interesting out there. There is some muted changes for trusts, and what Mike has contemplated in this process does not fall foul of those new changes. In fact, by keeping account of that present entitlement of a beneficiary of a trust, in this case a testamentary trust, you're not breaching any of the new laws, which is really interesting.
But just on that, those laws aren't new. They've been with us for ages. We're just now being told by the tax office how they're going to apply those laws. So, no, we've got nothing to fear in the way, and that's another concern that many people say is, I do this, spend a bit of money and get one of these smarter wills. What happens if they change the laws? Well, tax laws change every day of the week. But I don't see that there's ever going to be a change in the laws which provides a concession to orphans.
Yeah, well, the idea is it protects those minors if mum and dad get run over by a bus and that minor's got nothing other than...
And that's the principle that we're talking about here, which drives that concession. Incidentally, that concession, when it was introduced back in the 70s, was supported by both parties. And Bill Shorten, when he announced before the last election that he was going to review the taxation of trusts, made it clear that he wasn't targeting testamentary trusts or charitable trusts. So this is an area where it would be an unlikely scenario that these special concessions for infants would ever be interfered with.
Fantastic. Interesting enough, we established a trust. We've done the right thing, and we've fixed our leaky tap, and we've got the trust underway, or we've got the will, if you like, or our estate plan. How often do you sort of recommend opening the filing cabinet and having a look at that estate plan and giving it a refresh? What's it look like?
Oh, look, every now and then you've got to, like everything in life, you check the pressure on your tyres and your car, you check to see it's got oil. So, but look, you'll always make it easier on yourself when you sit down and put the will together, and this is what a smarter will generally do, is try and make it as future-proof as possible so as that you eliminate the need to be constantly. So in most families, say, if all that you've done is to appoint your spouse as your executor and you leave everything to him or her, and then after she dies, he dies, then goes to the kids equally, it's only if there's a breakdown of someone's relationship does that those set of principles need to be revisited. Yeah, you might change your executor as people come and go in your life, but ordinarily that sort of will doesn't need to be changed at all because you're not specifying particular assets. Now, in your will, you don't need to list every asset that you've got. All that most well-drafted wills say is that whatever I've got at the time of my death, and that can include superannuation and the proceeds of life insurance and whatever, whatever I've got, that is to be divided between these people, and generally it's an equal division. Now, I see a lot of other formulas. It could be 80% to the kids and 20% to the grandkids. So that's a fairly common thing that people do as they start to have a few grandkids. But invariably, if you do the will properly, there's not a lot that needs to be refreshed. So every now and then you just sit and have a look at it. The things that do change, gifts of little personal bits and pieces. The jewellery that your grandmother gave to you, you want to pass on to your eldest granddaughter and so forth. I generally build into the wills that I do the ability for you to leave a list of those things so you're not having to call in a lawyer every time you want to change your mind about that. So if you sit down and spend the time properly doing a comprehensive document, you hardly ever need generally to come back and keep revisiting it. That's my experience.
So the revisit would be either a marriage breakdown in this instance where might have a reverse,
or if you want to disinherit one of the kids.
Yeah, and or you've lost an executor, or you've lost a medical guardian or something, or want to change that.
Yeah,
and that change is not major. We're not talking about a whole redrafting. We're just simply changing your name and signing.
It's not a big deal at all. It's not a costly thing to do all over again.
I want to just focus on an area that I think we sort of glossed over through it really quickly. However, what I've seen in practice is there is a little bit of death tax around super. So super has these wonderful provisions around dependents, where if there's a dependent under a legal definition of dependency, super can flow through to that dependent and not be taxed. But if it's a non-dependent, as in an adult child that's not living with you or the like, there is this contemplation of taxes.
It's a superannuation death benefit tax, and it's a death duty on your super going to your adult children. It's 15% plus Medicare levy on the taxable, that part of your super in which you've claimed a tax deduction. It's the long and the short of it's a death duty on your super. So what the government has said is that, while you're alive, you've got a tax-free holiday with regard to your super, but the minute that you exhale your last breath, all those concessions are lost. And as money has to come out of super at that stage and be paid out into your estate to your grown-up children and what have you, then, your executor pays this superannuation death benefits tax.
Okay, so when you're looking at that, when you're contemplating the will, would you still keep them a little bit mutually exclusive in when you're looking at the superannuation distribution versus the balance of the estate? Is that a fair way to...
The strategy which I employ in every case is to provide in the power of attorney the ability of your attorneys to cash in your super. And at the family meeting with the grown-up children, I will then say, look, this is not an issue that will crop up while both your parents are alive, but after one of them has died, if it looks to you that the surviving parent hasn't got long to go and they've got super, sit down with your parents' accountant, financial advisor, and discuss winding up that super while they're still alive, because that, if it's done while they're still alive, zero tax. If it's done after they die, superannuation death benefits tax. So there needs to be a specific provision in the power of attorney which allows the children to go and orchestrate the commutation or the cashing in of superannuation if it, as I say, the surviving parent looks like they haven't got long to go.
Well, this could be a significant amount of money, so that's
absolutely
critically important.
Yeah, well, invariably it is. It's hundreds of thousands of dollars for many people. So, once again, this is a provision that needs to be incorporated into a power of attorney. Is it in the standard government-approved form? No. So where, once again, you need to be talking to people who've got skills in this area who can competently advise you, and it then needs to be communicated with the kids. And this is why this family meeting at the end of all things is so important, because not only can we discuss this, but also discuss termination of life support, simple things like funeral arrangements, particular other things, who to go to for assistance and advice, where do you get some technical resources. And I put together a bit of a folder for families so that there's a checklist for executors, because invariably the people that you've appointed as executors have never done the job before. Now, once again, I've never met anyone yet who bragged about how much fun it is to be somebody else's executor. It is a job. It's an intrusion into another person's life, and it's everything from cleaning out the garage to arranging sales to dealing with accountants and financial advisors and impatient beneficiaries who keep ringing you up saying, why has it taken so long? Well, because we can't get a tax clearance. So it's not a pleasant job, but if the executors are properly informed, properly educated, and they've been given a checklist which they can easily follow, geez, it makes a difference. And especially if the person concerned has got all their affairs in good order. Another example of something that's become very important is their digital assets. A recent example of a case I had involved an elderly guy. He died. His brother, who was quite elderly himself but was a few years younger, thought it would be a good idea if he contacted Facebook to let them know that his elder brother had died and to take down the page, because he had heard that that would be a good thing to do. So he went and did that off his own bat. He wasn't the executor, but he just thought it was a... So he goes and announces this to the three kids, and the kids say, what the hell have you done there? 14, 15 odd years of Facebook and all those memories and all those inputs and all those photographs and what have you, we've lost. We can't get it back. They've contacted Facebook, and Facebook says, we're not interested in, we've been told.
We've deleted it.
Deleted it.
Oh my golly gosh.
So
no one would think of that, would they?
Well,
it's very clever.
A competent estate planning lawyer does think of it.
Wow.
Because we are dealing with it all the time. Now, in the power of attorney and in the will, there needs to be a specific provision which authorises the attorney and indeed the executor to deal with the digital assets of the deceased.
That's fascinating.
Now, this is becoming a really important area of modern life, because someone's got to shut down all of your Facebook, your Instagram accounts and all those other bits and pieces, preserve all the 60 or 100 odd thousand photographs that you've got on iCloud or whatever. These are very important, very valuable family information that needs to be curated professionally by...
Tell me, given the extent of the work, and I dare say some estates would be quite comprehensive, are executors often compensated for in the will, or is it outside and they might seek professional advice? How does that work?
Look, if they're getting professional advice, the accountants and financial advice, mostly it's financial and accounting advice that they need to get. The legal work, if they've got a good will, legal work's minuscule. It's routine. Almost anyone can do it. It only becomes expensive legally if they don't do the job very well. But mostly it's accounting and financial, and the cost of hiring accountants and others is paid by the estate. But the executor, if the executor is a beneficiary and they're a family member, they'll often say, yeah, I'll do it and I'm not going to charge for it.
But I just sort of have the right to pull in the professionals I need, and that's generally allowed for.
Well, in a good, smart will, they're told to do that.
Yeah.
So that they don't have to explain that to anybody else, because it's a direction in the will for that to happen. Generally, if the deceased's accountant and financial advisor is involved in the administration, you get a much better job done, and everyone can see that. So no one ever complains about.
Seek the advice and get the right advice. Mike, this has been absolutely fascinating, and we've really glossed over it. I know this is a very technical area, and you're an absolute specialist here. In terms of you, are you happy? Are your doors open to take all and sundry if people want to get in contact with you? Well,
I've had a long professional association with NavWealth going back 20 years, really. So, and I've helped many of the firm's clients deal with their estate planning, continue to do so. So the answer to that is yes. That's what I do. Mostly, I work with other professionals who are referring me their clients, so that we work together as a professional team, and that makes it more effective. But of course, always happy to have an initial chat without any cost or obligation, just to sort of see what needs, what each case needs. And generally, I charge on a fixed fee basis. It's not hourly rates. It's an agreed fixed fee up front. Before you start work, you agree on a fixed fee, and that covers it.
Well, the elephant in the room, typically, because this sounds very complicated, and everyone's sitting at home probably worrying how costly it might be. What's your typical range of fees on that?
In the great majority of cases, it's $3,500 to $4,500 plus GST. Now, because I'm a chartered tax advisor as well as being a lawyer, and where I've had to review the tax implications associated with the particular estate, then that part of my service is fully tax deductible. So, generally,
so it's tax deductible. It's 3.5 to 4.5, which is absolutely nothing in the bigger picture when you're dealing with a lot of money that could go south.
Oh yeah, it's a good investment. I would have thought. I'd mostly hear. Well, in fact. Almost in every case, I suppose. There's always the odd one that might not. Most people feel that that's good value for money if they're getting all the hard work done and some expertise along the way. Sometimes there's a slight additional fee for the family meeting, because sometimes in order to get the family together, you've got to meet them on a Saturday or after hours to get everyone there. When you have those family meetings, and I encourage that in almost every case, it's important that all the family are there at the one time. You can't do it piecemeal, and that doesn't have the same impact.
Cloak and dagger again.
Yeah, so but with Zoom and what have you these days, I mostly do these things at about 6 o'clock most nights. I'm sitting down with families. I did one last night where one child was in London, and the other child was here, and parents were somewhere else. So yeah, it's with Zoom you can have these family meetings and do good work, and answer everybody's questions and settle everybody down in sort of 40 minutes to an hour.
Great. And look, the testamentary trust was structured right with the right beneficiaries. You'd save that fee in the first year's distribution anyway.
Oh, absolutely. Probably the first 3 months of distributions, actually. So
now, I want to just circle back one question I've got in all this, and you mentioned it very early on, and you said in your early days you walked into a legal firm and you found yourself drafting a will, which is pretty scary in terms of an 18, 19-year-old and freshly out of law school. In terms of finding the right person to do this, what's your advice for anyone out there who might be contemplating a will, other than, of course, speaking with yourself, but there's only one of you and there could be a lot of people out there. How would you go about finding the right lawyer who's going to help you and knows this space?
Yeah, well, I think this is why it's important that you have this conversation with your financial advisor / accountant, because invariably they will know who is good. So for the average person to try and go into the legal market and try and source out who's any good, it's pig in a poke stuff, really. If I can say this, that if you are going to do that, look for someone who's a member of the Society of Trust and Estate Practitioners, STEP. So they are lawyers and others that need to be specially qualified to be able to be a member of that organisation, or someone who is an accredited specialist in the States. Although the accredited specialisation in the States often relates to people who specialise in contesting wills. You don't need someone who's good at contesting wills. You need someone who's good at drafting wills. So someone with some tax and other additional qualifications is generally a good thing to see.
I mean, from this discussion, I think we've got enough topic references for anyone to take on board and go and really have an educated discussion with the person who might be contemplating to draft their will.
Yeah. Hey, look, one thing I can say, I've written an article called "Why Everyone Should Upgrade to a Smarter Will." So if anyone listening to this, if they get in contact with you, I'll happily send that to them as an email attachment so they can have a look at. That speaks about the features and benefits of these trusts and how they're used in the modern world.
Michael, I couldn't thank you enough for your time today. It's been a very interesting discussion and one where I've learnt an awful lot on the topic matter. Thanks for joining us today for NavTalk. You can listen to other podcasts in the NavTalk series via YouTube or where you get your favourite podcasts, or simply search NavTalk. Be sure to follow NavWealth on LinkedIn, Instagram, Facebook or Twitter. And please, if there are any particular topics you would like us to cover for a future episode, let us know via our website. I'm Simon Prowse. Until we talk again.